My name is Elle Bernstein. I'm a member of one of the Federalist Society's practice groups. I'm so excited to welcome everyone to this morning's panel, The Future of Family Autonomy After Mahmoud. This event is being co-sponsored by the Federalist Society's new education practice group and the Family and Parental Rights Network. The family is the building block of society, a principle articulated by Aristotle and embraced by the American founders. Political community is ordered toward fundamental human goods, goods that we cultivate and learn to pursue first and foremost in the context of the family. The strength and vitality of the family unit is therefore of utmost importance to a flourishing society. The Supreme Court has addressed the rights and the role of the family on various occasions, most recently in its decision this last term in Mahmoud v. Taylor. We have a distinguished group of panelists to discuss that decision and what it means for the future of the family in the United States. I will let our moderator introduce our panelists. It's my honor to introduce our moderator, the Honorable Michael H. Park. Michael H. Park serves on the United States Court of Appeals for the Second Circuit. Before his appointment to the bench in 2019, Judge Park worked as an associate at WilmerHale, a partner at Becket, and an attorney advisor in the Office of Legal Counsel at the Department of Justice. Judge Park also joined Consovoy McCarthy Park as a named partner. He clerked for then Judge Samuel A. Alito on the Third Circuit Court of Appeals, and then for Justice Alito. Judge Park holds an AB from Princeton University and a JD from Yale Law School. Please join me in welcoming Judge Park.
Thank you. Good morning. Thank you for the kind introduction. Thanks everyone for coming. Can you hear me? Is this on? Okay. Thanks to the Federalist Society for putting on this event and for an amazing convention. I want to begin by setting the table. Last term, the Supreme Court in Mahmoud versus Taylor reaffirmed the right of parents to direct the religious upbringing of their children. Some quick facts for those who aren't familiar. Montgomery County had introduced LGBTQ+ inclusive storybooks for elementary school students without allowing opt-outs. Plaintiffs were parents from diverse religious backgrounds with sincere religious beliefs on sexuality and gender. They wished to pass those beliefs on to their children. The Supreme Court granted an injunction requiring Montgomery County to let parents opt out of this instruction. The decision relied heavily on Wisconsin v. Yoder, a 1972 case that struck down a compulsory education law because it substantially interfered with Amish parents' right, quote, to direct the religious upbringing of their children. Parental rights have a long history, going back 100 years to Pierce versus Society of Sisters, which held that the Constitution protects parents' decisions to send their children to private religious schools instead of public ones. So, in light of Mahmoud, this panel will discuss the state of the law on parental rights and how it might shape parental authority in other areas of education as well as in other contexts. We have a distinguished panel of experts to guide us through these topics. Their full bios are available online, but let me briefly introduce them. To my left, Will Haun is Senior Counsel at the Becket Fund for Religious Liberty and a non-resident fellow at AEI. He served as second chair in Mahmoud and worked on the Supreme Court team in Fulton versus City of Philadelphia. Professor Nicole Stelle Garnett, on the other side over there, is John P. Murphy Foundation Professor of Law at Notre Dame Law School, where she also serves as Associate Dean for External Engagement and directs the Notre Dame Education Law Project. Her work focuses on education law and policy, religious liberty, and property law. And finally, Michael Bindas is a senior attorney with the Institute for Justice, where he leads IJ's educational choice team, which helps policymakers design constitutionally defensible educational choice programs and then defends those programs in courtrooms across the country. Our format for today is we'll begin with some relatively brief opening statements from the members of the panel. Then we'll have a time of discussion after that, and we'll leave some time, of course, at the end for questions from the audience. We'll be concluding by 12:30. So with that, let me turn it over to Will.
Thank you, Judge, and thank you all. Good morning. I thought I would help us start by just kind of framing a bit more the stakes of Mahmoud and then its implications. So I think you can look at Mahmoud and see the stakes really distill to a single question, and that's who decides? Who decides the religious upbringing of a child? Is it the family or is it the state? Now that answer may seem obvious to many of us, and it may seem obvious when you look at the long tradition of parental authority, but it's not actually been all that obvious to U.S. law for a very long time. And that's partly what makes Mahmoud so monumental. When you look at this case, you could look at it and see really an effort by the parents to want to restore what was a consensus position in Montgomery County and also throughout the United States. These books were introduced in 2023 around highly sensitive topics on sexual orientation and gender identity. They navigated pre-K students through a pride parade. They talked about third graders engaging in gender transition and how to normalize that with their parents. And then there was instructional guidance that was given for the teachers to have conversations with the students about these books that included things like if a child raises his hand and asks, well, I thought if you're born a boy, you're a boy, and if you're born a girl, you're a girl, the teachers were instructed by the board to say things like, that's hurtful, that's offensive, you can't say that. Only doctors, when you're born, are just making a guess about who you are, only you really know inside. Sort of armchair sociology just kind of like shot through the instruction guidance and the books themselves. And so naturally this was distressing to many parents of many diverse religious backgrounds as well as those who simply wanted to respect parental authority. And they wanted opt-outs. They wanted to know when their children were being instructed in this and give them the opportunity to opt out. They had that for most of the first school year where these books were introduced. But then in March of 2023, with no public explanation, the school board just pulled notice and opt-outs away for these books and only these books. You could get opt-outs from everything else that Montgomery County Public Schools teaches, but you will never be allowed to know when these books were going to be read to your kids, and you could never opt them out of the instruction or discussion. This resulted ultimately in a broad, diverse coalition, religiously diverse coalition of families who wanted to sue to restore this consensus position of an opt-out. It's a position that's reflected not only in the county's policies, but also Maryland law and every state in the country that has ever spoken to the question of family life and human sexuality instruction in schools. So this should seem like common sense, but as I mentioned, for most of U.S. history, it's been much more patchwork. When you think about when public schools came on the scene in the 19th century, there were a lot of early controversies, particularly around Catholic immigrant children who could not, for religious reasons, recite the Protestant version of the Ten Commandments or the King James Version of the Bible. This culminated in controversies like the Elliott School Rebellion, where a little child in Massachusetts was beaten until his hand bled because he wasn't going to engage in these exercises. You then go a little bit later into the early 20th century and you get Pierce versus Society of Sisters and Meyer versus Nebraska. We think of these cases as involving just the liberty of parents, but religion was going on in the background of these cases. If there's any doubt about that, you can just look at the title of the Pierce case. It's Pierce versus Society of Sisters of the Holy Names of Jesus and Mary. So that kind of leaves no ambiguity as to what's going on in the background there. The Ku Klux Klan was trying to shut down access to religious schools, and that was the genesis of these lawsuits. Go a little bit later into the mid-20th century, and you get Jehovah's Witnesses children who cannot, for religious reasons, be forced to salute the American flag. A little bit later, you have the Yoder case in the Amish and needing to go out of the last 2 years of high school, which high school itself was relatively novel. But since Yoder, what had been happening in the lower courts is that Yoder and parental rights was effectively read out of the Constitution in public schools. If you went to public schools, you were told your remedy is the democratic process. But as we saw in Montgomery County, the boardroom doors were being closed to the parents. Over 1,000 people showed up at the last school board meeting, and the response from the school board was to close the doors and call the police. And when the boardroom doors are closed, that's when the courthouse doors need to be open. So that's why the parents brought this case, and for the first time in over half a century, Mahmoud vindicates the principle that parents do not surrender their authority to direct their children's religious upbringing just because they send their kids to public schools. If anything, the parents should not be doubly taxed for having to pay for the public schools in the first instance, and then be subjected to criminal penalties if they cannot find an alternative means of educating their children except for leaving them in a religiously burdensome environment. I'll leave one more takeaway from Mahmoud and then turn it over to the panel. Mahmoud opens up the second area in free exercise jurisprudence where the court has said you don't need to show what Employment Division versus Smith requires you to show before you bring a free exercise claim, and that is essentially that the government discriminated against you first. It is simply the fact that parents, as their own society, it was mentioned at the beginning, their own authority on these matters, that they can bring a claim. That's one of two areas where this happens now. It's the family and it's church autonomy. And this reflects an Aristotelian principle. It's also reflected in Catholic tradition. It's known as the necessary societies, that there are certain entities that don't get their legitimacy from a state permission slip. They have it by higher means. And as the U.S. law kind of encounters this, hopefully it will develop a vocabulary for religious freedom that respects the fact that we are being formed, as Pierce said, in higher things.
Does this work? Can everybody hear me? No. How, where? Hello? Oh, hi. Okay, this is great. I'm so happy to be here to talk about Mahmoud. I think it's somewhat ironic, if you know me well, that I might be here to be the thoughtful moderate and talk a little bit. Anyway, that's a role that I rarely play. Hopefully I'm thoughtful, usually. Anyway, so I want to make 3 observations about Mahmoud, and then one observation about where we are more broadly with respect to parental rights. Okay, so the first is that I think there's a colorable claim that can be made that Mahmoud reframes Pierce as a religious liberty case. Now, Mahmoud was a religious liberty case, but Pierce was not a religious liberty case. It was a liberty case. It was a substantive due process liberty case. I mean, it says the fundamental theory upon which our nation reposes, a fundamental theory of liberty upon which our nation reposes, prevents the state from doing this, prohibiting parents from sending their kids to religious schools. And so I think that's understandable. First of all, it was a religious liberty case. Everybody knows that religion is in the background of Pierce because it was the Society Sisters. It was also a secular military school. The second reason I think it's understandable is that the Supreme Court, supermajority members of the Supreme Court right now, are not super high on substantive due process. And so reframing of the doctrine here into being Pierce about religion and religious liberty, religious parents' rights, it makes them it's a more comfortable space for the majority of the court. And there are some other cases pending that don't have these religion claims. I don't think there's going to be a huge appetite for expanding Pierce, but we'll see. Okay, so this reframing of Pierce as a religious liberty case has major implications. As I read it, the reason the parents won is that the policy was not generally applicable because there were other exemptions. And so therefore, because it imposed a substantial burden on religion and it didn't satisfy strict scrutiny, the parents win. But these things won't always be present in parents' rights cases because not all parents' rights cases are religious. I mean, many are not. I mean, I consider, for example, the Rosencrantz debate, which will follow about secretly transitioning in public schools. Those claims are compelling, but I don't think they're religious. I mean, maybe some of them are, but not in the main are they religious. So one of the questions might be, what happens to non-religious parental rights claims? Do they have any space in the court anymore? Do they need to go to state court? Those are questions beyond the scope of my limited knowledge, but I do think it is an interesting development. The second thing I would say about Mahmoud is, although it was broader than I thought it would be, I thought the parents would win. And I imagine there are lots of litigators out there right now filing lawsuits or looking for lawsuits to demand accommodations from various public school policies. And I imagine there are plenty of good candidates. But one could expect that many administrators will resist their demands for accommodation, and many judges will defer to their assertions that they have compelling reasons to do so. In some cases, they will. Not everything can be accommodated in the public schools, and Justice Alito acknowledges this in his opinion. He says, look, public schools are complex places, and as a general rule, schools have a compelling interest in having an undisrupted school session conducive to student learning. The problem is with Montgomery County was it was letting kids opt out of everything, and so they had no reason to think that the no opt-out policy was was advancing a compelling interest. Not all school districts will be this sloppy. I mean, I assume many will, being the government and all, but sometimes not all kids can be accommodated. The third point I would just make is that I think one of the most important lessons to take from Mahmoud is that religious liberty and parental rights is best served by giving parents choices outside of the traditional public schools, especially private school choice programs that include religious schools. The nature and mission of state schooling on the one hand and our constitutional commitment to religious liberty on the other will inevitably conflict. Just as McReynolds said in Pierce, that the goal of public education is to standardize children by exposing them to the ideals that public educators deem necessary to form good citizens. That was Montgomery County's argument in Mahmoud. It is inevitable these conflicts will conflict, and in today's culture, many ideals of public educators, the ones that we need to standardize our children to embrace, tend to be left-leaning ones that many parents find objectionable on religious and non-religious grounds. And I also will just point out that some parents must, for religious reasons, send their children to religious schools. They feel religiously compelled to do so. Okay, two last points. First, it might be tempting to think that we can leverage Mahmoud, maybe even Pierce, to demand parental choice as a remedy, as an opt-out, publicly funded private school choice. I don't think Mahmoud or Pierce will ever be stretched that far. But the last thing I want to point out is that thankfully parental choice is ascendant. 35 states have one private school choice program, at least one. 18 of them extend eligibility to participate to all children, and 50% of all kids are now eligible to participate in a private school choice program in the United States. It will be closer to 60 when Texas comes online next year. And that is a tremendous victory for parents' rights to direct the upbringing of their children. And I think it is arguably one that is at least as important as Mahmoud. So thank you.
So I think my comments are going to kind of dovetail nicely from Nicole's insofar as we're talking about Pierce being a non-free exercise case, and we're also talking about school choice. I defend school choice programs for a living, and for the last 30 years or so, the legal battles over school choice did turn on religion, right? First, opponents of choice claimed that these programs somehow violate the Establishment Clause because religious schools are allowed to participate. The Supreme Court thankfully rejected that argument over 2 decades ago in Zellman versus Simmons-Harris. Then they started arguing, well, even if these programs are permissible under the federal Constitution, they still are impermissible under state constitutions under the Blaine Amendments that prohibit public funding of religious schools or sectarian schools. And thankfully, in a pair of decisions in 2020 and 2022, the Supreme Court put that argument to rest as well, Espinoza and Carson, where the court said that to apply state law provision as a prohibition or a ban on religious school participation in these programs would violate the Free Exercise Clause. But opponents of these programs are a dogged bunch, and they have not just packed up and gone home after Zellman. They didn't pack up and go home after Carson and Espinoza. They're changing their tune, and now they're saying that even if a state constitution cannot prohibit religious options specifically in choice programs, a state constitution can still ban school choice programs altogether. And so they're now attacking these legislatively enacted choice programs and asking courts to invalidate them on this theory, that their state constitution prohibits the legislature from providing any financial aid to any student who opts out of the public school system. There are two state constitutional hooks that they hinge this argument on. One is the provision in a number of state constitutions, I think it's in the teens, that do prohibit public funding of private schools or schools not under the absolute control of the state. So not religious schools specifically, but private schools more broadly. The other state constitutional hook that they hang these arguments on are the education articles in every state constitution. These are provisions in state constitutions that require the legislature to provide for a public school system. And opponents of choice argue that implicit in this obligation to provide a public school system is a prohibition on providing educational opportunity outside of the public school system. Now, there are very good state constitutional counter-arguments to both of those points, right? Number one, the provisions that prohibit public funding of private schools, they're not even implicated by school choice programs because school choice programs don't fund schools, they fund families. This was the very basis of the Supreme Court's Establishment Clause holding in Zellman. And as for the provisions obligating the state legislature to provide for a public school system as somehow implicitly prohibiting additional educational options, I mean, that's just an absurd argument, right? If you tell your children, go take out the trash, that doesn't mean that they can't also go clean up their room, right? Imposing an obligation to do one thing is not a prohibition on doing anything other than that one thing. But not every state court has seen things our way. Most famously, 2 decades ago, the Florida Supreme Court, in a case called Bush versus Holmes, actually bought into our opponent's argument that the state constitution prohibits voucher programs in Florida under that state constitution's education article. Nothing to do with religion, but with respect to private schools across the board. Thankfully, for the next 2 decades, the argument got little traction, but in 2024, the South Carolina Supreme Court expelled private schools from the state's ESA program under the state constitution, and just this year, 3 state trial courts have bought into this idea that their state constitution prohibits private school choice programs, religious or not. We at IJ maintain that this move, interpreting a state constitutional provision to impose a blanket prohibition on financial aid for families who opt out of the public school system, and in turn applying that provision to invalidate a program that the legislature has provided to aid such families, violates the federal constitution. Why? Well, this is where Pierce comes in. The prohibition and invalidation turn on one thing and one thing only: the fact that these parents have exercised their fundamental right, recognized in Pierce, to opt their children out of the public school system. And this is no different than in Espinoza, right? There, the Montana Supreme Court had interpreted a provision of its state constitution as imposing an absolute ban on financial aid for religious education, and it invalidated a legislatively enacted choice program under that state constitutional provision. The U.S. Supreme Court correctly said that the Montana Supreme Court's decision violated the federal constitution, specifically the Free Exercise Clause, because it invalidated the choice program, because its invalidation of the choice program penalized parents for exercising their fundamental right to direct the religious education of their children. In this new scenario that we're seeing, the fundamental right at issue may be different, right? It's the fundamental right to choose a non-public education for your child rather than the right to choose a specifically religious education for your child. But the federal constitutional problem is still exactly the same. Invalidating the choice program penalizes parents and children. That is, it denies them a public benefit that the legislature has seen fit to provide them simply because they have exercised a federal fundamental right. That's a problem under the Due Process Clause. The Supreme Court has repeatedly made clear that the state cannot condition the availability of a public benefit on the surrender of a fundamental right, nor may it penalize someone for exercising such a right. And it's a problem under the Equal Protection Clause as well. A state cannot single out one group of citizens in its constitution and impose a special disability on them and them alone. As the Supreme Court held in Romer versus Evans, striking down a Colorado constitutional provision that did just that, central both to the idea of the rule of law and to our Constitution's guarantee of equal protection is the principle that government and each of its parts remain open on impartial terms to all who seek its assistance. Thus, a law declaring that in general, it shall be more difficult for one group of citizens than for all others to seek aid from the government is itself a denial of equal protection of the laws in the most literal sense. And that is exactly what these supposed state constitutional prohibitions on financial aid to non-public school students do. Only it's even worse than it was in Romer for 2 reasons. These provisions don't just make it more difficult for one group than all others to seek aid from the government, they make it impossible. And these provisions define the impacted class of citizens based on their exercise, again, of a fundamental federal constitutional right. There was no fundamental right at issue in Romer. and yet the Supreme Court still invalidated that state constitutional provision under rational basis review. The situation here is even worse. And in fact, when you consider the overall regulatory backdrop of education, the situation here is uniquely egregious, right? You have the US Supreme Court on one hand, recognizing a negative fundamental right to direct the education of your children, including specifically opting them out of state-run schools. And then you have the states, number one, compelling you to provide, under pain of imprisonment, to provide an education for your children, providing you a positive state constitutional right to get a free state-administered education in a state-run school, taxing you to pay for those free, supposedly state-run schools, and then, as our opponents would have it, constitutionally barring you from even the possibility of obtaining a single penny in financial aid if you don't use those state-run schools. Those elements of compulsion and coercion, right, the compulsory nature of education coupled with the coercive consequences of our opponents' arguments, place this situation uniquely at the intersection of Romer, which again prohibits government from constitutionalizing disfavored treatment for a particular group of citizens, and the unconstitutional conditions doctrine, the very purpose of which is preventing the government from coercing or leveraging people into giving up a fundamental right. And it's hard to view this situation as anything other than an attempt to evade, to do an end run around Pierce. Our opponents cannot make every child attend a public school. That would clearly violate Pierce. So instead, they're trying to do the next worst thing, indirectly coerce or leverage children into the public schools by cutting them off from even the possibility of aid from the state if they exercise the fundamental right recognized in Pierce. As Chief Justice Marshall wrote for the court exactly 2 centuries ago in Wayman versus Southard, what cannot be done directly from defective power cannot be done indirectly.
Let me begin the discussion by just opening the floor to the other panelists and see if there's any reactions or responses to things that you heard from each other.
Yeah, I'll go first. I want to just kind of spend a bit on the idea of thinking of Pierce and Meyer kind of properly as religious exercise cases. So these cases, and I believe Justice Thomas has pointed this out, they were decided before the Free Exercise Clause was incorporated against the states. So it's not like the Supreme Court was presented with an opportunity to think through this as a free exercise protection explicitly. Moreover, in the substantive due process context, there's an analysis of history and tradition when you analyze whether or not there's an unenumerated right that's protected by the Constitution. When you do this with regard to parental religious direction, parental religious direction has a long-standing lineage. I mean, it goes back well before the founding of our country. Parental direction in education and the rise of public schools, however, raises many more complicated questions around what exactly is the nature of the public school's authority. So if you look at separate writings from Justices Alito and Gorsuch and Thomas in the Mahanoy case involving student speech, they get into some of this in some detail. The whole doctrine of in loco parentis, which developed about the nature to which we think about the role of public schools and what kind of authority they have that's been either delegated from the parents or authorized by the democratic process, gets into some really difficult questions about, well, what was the scope of the delegated authority from the parents to the public schools? How do we think about that in light of modes of education that predate the public schools, that really have no resemblance to public schools? There's not really a historical analog to public schools before the mid-19th century. And then you would need to think about, well, what is the role of the democratic process in all of this? They enacted the public schools. So what I think those separate writings point to is a couple of helpful guideposts that might explain why it's not a coincidence, and not just in Mahmoud, but frankly every single Supreme Court case that's ever been had involving parents and education, they're all religious cases, every single one of them. And because one, when parents are directing the religious upbringing of their children, they really are, as Pierce says, forming them in higher duties. So it helps us respond to the idea of our freedom on matters of religion as responding to an authority that truly does transcend the state. It'd be hard to say education transcends the state. Moreover, the idea, and this is particularly pointed out by Justice Thomas in Mahanoy, there's also the issue of a lack of the parental knowledge. So one way where the gender transition cases involving substantive due process might be able to invoke substantive due process successfully is because the parents are being cut out of the process. And whatever they're not being told about what's going on to their kids at school. And whatever complications exist around what authority was delegated to the schools, in any kind of principal-agency relationship, when the agent cuts out the principal, I think it's fair to say the agent has exceeded the principal's delegated authority. So that makes sense in that context, but when you get out of that context, you get into these complicated questions about what was actually delegated to the schools from the parents, how does that relate to in loco parentis, and frankly, the Supreme Court has rather studiously avoided the scope of in loco parentis, and every single occasion it's had the opportunity to discuss it. So I think there's good reason both for how substantive due process has developed, the history of public schools and parental authority, and then the reality that religious duties really do transcend state power. These are all good principled reasons to understand these cases as religious exercise cases.
So, I mean, this is where I'm ceasing to be a thoughtful moderate. I don't like substantive due process, and so I'm uncomfortable with arguments that are grounded in substantive due process. Now, I think I'll just make 2 points. The first is about parents' rights generally, and then whatever the parents' rights generally are, the parents' rights in public schools. The first is, look, I'm open to the idea there are unenumerated rights protected by the Privileges or Immunities Clause of the Constitution. I am, and I think if you sort of read, Justice Thomas's McDonald opinion of a sort of like what were the rights that were denied to slaves, parental rights. I mean, I think I'm comfortable. I'm okay with exploring that. I have a paper, a student is writing a paper for me about it, and he has some pretty good evidence, both that there was something akin to parental rights that were protected. Perhaps we would think of them as a privilege or immunity. That would make me a lot more comfortable than substantive due process. So then the question is, but how big is that right? What is that right? So does that right, I'm leaving aside religion now, if it's for a secular claim, parental rights claim, how far does it penetrate into the public schools? What is it the public schools, how do they have to accommodate these rights? And I do think that it's very difficult to figure out. First of all, there were no public schools at the time of the founding. They're a 19th century invention, and even well into the 19th century, they're nothing like governmental school districts that we have now. So we don't have any good analogs to fly back on. The second, just as a practical matter, public schools are complicated places, and it really is hard to negotiate with a lot of parents that have very distinct views about what should be taught to their child and not, and maintain order. There is no such thing as a values-free education. There is no such thing as a value-free education, which is why I'm a parental choice advocate, and I send my kids to private school. So I do think those are something, things to think about. And as to Michael's point, Michael and I I'm a former IJ attorney, and I filed the first case challenging the law that was finally rejected and invalidated in Carson, and Michael actually 25 years later won the lawsuit.
You set me up nicely.
The reporters got really confused. They're like, how do you feel about winning your lawsuit after 25 years? I'm like, it's not the same lawsuit. But I worry a little bit about leveraging peers too much in these cases. I really agree with you that these arguments are stupid. I teach state con law too. State constitutions, the expressio unius principle doesn't even apply in the state constitutional context because they are not documents of grant. They are documents of limitation. It doesn't make sense to say set up public schools means you can't do other stuff. That makes no sense. But I worry about leveraging peers too much because our courts are increasingly formalist, skeptical of substantive due process arguments, and then I worry, no offense, that it might backfire. So we have to be very careful that we are not putting too many eggs in substantive due process basket to protect what I consider to be a cornerstone of parental liberty, and that is this dramatic and moving and awesome expansion of private school choice in the United States.
Just a few points on both Will and Nicole's, your comments. So there have been countless attempts to redefine Pierce and Meyer as anything other than substantive due process cases, right? There are certainly attempts to redefine them as free exercise cases. Footnote 4 in Caroline Products tries to define them as cases turning on discrete and insular minorities. I think it was Justice Kennedy in Troxel, his Troxel dissent, I think tried to redefine these as free speech cases. They're substantive due process cases. They're rooted squarely in the Lochner era. The strange thing is, unlike virtually everything else that's been discredited from the Lochner era, these cases are considered canonical, right? So presumably, the court, I think it's increasingly evident that even the justices most skeptical of substantive due process and unenumerated rights believe that the outcome in Pierce and Meyer was correct, right? Increasingly, we've seen concurrences from Justice Alito relying on Pierce, relying on Meyer, Justice Gorsuch joining these, Justice Thomas saying that strict scrutiny should have been applied in Troxel because the case involved the right recognized in Pierce. So presumably, even the most hostile justices to substantive due process think the outcome was right in these cases. But they're uncomfortable, I think you're right, with the constitutional underpinnings of these cases in substantive due process. And I think that perhaps means that this fundamental liberty interest, which the court has called the oldest of the fundamental liberty interest recognized by the court, is perhaps the perfect vehicle to begin the process of revitalizing the Privileges or Immunities Clause as the appropriate vehicle for providing substantive protection to unenumerated rights. Right? These cases precede everything that came after Lochner, the bifurcation of rights into fundamental and non-fundamental, the incredibly deferential rational basis test that applies to unenumerated rights for the most part, the turn to beginning, providing some meaningful protection again in the 1960s and 70s for at least some unenumerated rights. Pierce and Meyer predate all of that. And the court has never grappled with how to apply everything that happened after Pierce and Meyer to Pierce and Meyer themselves, right? We still don't know what the scope of the rights from Pierce and Meyer is. We still don't know what test, what level of scrutiny even applies to an abridgment of the right recognized in Pierce and Meyer. It's a blank slate, and I think for that reason, it would be the perfect opportunity for the court to begin the process of, again, revitalizing the Privileges or Immunities Clause as the appropriate source of substantive protection for unenumerated rights, including this one.
Will mentioned earlier that the court in Mahmoud did not take the Smith approach and relied more on Yoder. How does that, if at all, interact with kind of exploring the more, original doctrinal foundations of Pierce and Meyer?
So I actually had a question about that. I mean, when you say it doesn't take the Smith approach, I mean, wasn't one of the flaws of the program it's not generally applicable, so because they had the other options. I take that to be the post-Smith Fulton approach or the most favored nation COVID case approach. So, I mean, I think these cases are fascinating. I mean, we're seeing a lot in of people, you would know this, like Becket has the pre-K case in Colorado where, the condition is you must not discriminate on the basis of LGBT status or you cannot participate in this pre-K program and get the money. But we're going to allow monkeying around with different, eligibility criteria over here so you can pick your kids, but not these kids. And then there's this sort of a fight about, is that generally applicable, assuming it's religion neutral. So that is present in Mahmoud too, right? So when you say not the Smith approach, I take Smith to mean if a law is neutral and generally applicable, it's constitutional. But if it's not, then we just get out from under Smith altogether, and more cases are coming out on that general applicability question.
Well, so you're certainly right that Montgomery County's policy was would have absolutely failed Smith's inquiries, and we definitely made those arguments. But the Supreme Court's opinion is very clear that because the burden in this case was like the burden in Yoder, there was no need to ask questions of neutrality or general applicability. So when the burden is like the burden in Mahmoud and like the burden in Yoder, in other words, the burden on a parent's authority to direct their children's religious upbringing in a school, there is no need to show Smith's neutrality and general applicability inquiries.
We could switch from some of the doctrinal conversation to the more practical consequences, and I want to start with Mahmoud itself. The dissent warned about opening the floodgates to challenges to public school curricula. Do you think that's a legitimate concern, and what can we expect to see on that front?
No, it's not a legitimate concern. As my colleague Eric Baxter said to the Supreme Court, and we pointed out in briefing, as well as more than half the country of U.S. states showing up supporting us, didn't think that the sky was going to fall in their jurisdictions because they were going to do what was already being done in 47 states, which is that when you teach children matters of family life and human sexuality, you let parents know that and you let them opt them out. And in fact, many states go even broader than that with their opt-out accommodation policies, and I think it's also interesting to note how Montgomery County itself responded after it lost Mahmoud. For all of the hemming and hawing, they have now adopted what they call a refrigerator curriculum, where they are telling parents everything under the sun that is going to be taught to their kids at every possible point in time and letting you opt out for it. So that if the sky is going to fall, we just have never seen that happen.
Will, if Maryland had had a meaningful school choice program, do you think the outcome of Mahmoud would have been different? If parents had the ability to meaningfully opt out through a voucher or an education savings account, would the outcome have been different, or at least the analysis?
Well, it won't be too flip, because I do send my kids to a classical Catholic school in Maryland. But I will say that, I mean, that's a question for Governor Moore. I mean, I think when it comes to the burden in the case in Mahmoud, what was pointed out by the court rightly, and it played into or picked up on the Trinity Lutheran Carson Espinoza line of cases, is that when you have made it financially prohibitive to go to a non-public school, that only reinforces the coercive nature of the burden by forcing the child to be in public school on pain of criminal penalties. We had one client in the case for whom trying to replace the services that her child with significant learning needs had would have cost them about $25,000 a year. We had another family who moved precisely so that they could be within walking distance of their children's school. And now they were forced to try to find a private option at the cost of tens of thousands of dollars. So it is the case that the financial burden on the parents underscores the coercive nature of the religious burden in the schools.
So I don't think Michael's question is a good one, and I've thought about it. I mean, like Florida, everybody gets, what, $8,500? Indiana, everybody gets $7,500. I mean, Texas, it's going to be 10, but not everybody, because there won't be enough vouchers. But I think that's it's an interesting question to ask. Well, would Mahmoud come out differently in Florida? I think it can't, for the same reasons that would the court really get into, is $8,000 enough to get us? You just got through telling me how much pre-K costs in New York City, and $8,000's not getting you there.
It's close to $70,000.
So I don't think the constitutionality of the situation in Mahmoud is going to vary by state, depending on how they've chosen to fund or not fund private schools. But certainly, to my point, the burden on parents, if you are able to send your child to a private school, if you get that ESA or a voucher, and you are able to opt out of private schools, public schools and into private schools, that is, for philosophical reasons, really important. I mean, my kids go to Catholic schools, and I've seen over the since we got vouchers, just the total complete transformation of Catholic education in South Bend, Indiana, because all of these families that couldn't previously afford to send their kid to St. Joe Grade School cops' kids, immigrants' kids, and they're just changed everything. And that is really an important parental rights victory, even if it's not constitutionally relevant.
Nicole, you directed us to a recent Texas parental rights amendment, and it just passed, and it says parents have a right to exercise care, custody, and control of the parent's child, including the right to make decisions concerning the child's upbringing. What's behind this? What will it do? What are its limitations? Can you all speak to that a little bit?
I'm not a Texan. I could guess somebody in the audience. So it is an interesting development. I think there's federal legislation along the same lines that is pending. I think there's state statutes that do these things. I actually think for the non-religious parental rights cases, I think the state courts are not a bad place. State constitutions are not a bad place for those to be vindicated. State constitutions are easier to amend, so if court gets it wrong, they can fix it. State courts are more often, I teach state con law, they're more comfortable with what we might think of as sort of policy determinations. I saw at least one justice here. He can tell me why I'm wrong. Wait, we have a Texas justice was here earlier. Okay, but so I don't think that's I think it's not a bad place for them to go. I do think that what you just read, Judge, you could pour a lot into that language. And it's also really important to remember these parental rights cases are not only conservative cases. They're often quite progressive parental rights cases as well, including a la Scrimeti. I have a peer's right to have these drugs for my children. So Texas is going to invite, I think, both with that language. So I think it would be wrong at the Federalist Society to think this is just a conservative cause. It's not. These cases run both ways.
I think having a provision like that in a state constitution will make it more difficult for opponents of school choice to say that these other provisions of the state constitution that I spoke of require invalidating a program that the legislature adopts to empower parents to exercise the very rights that the state has now just enumerated in its constitution.
So you've a couple of you mentioned non-religious liberty parental rights claims, but I'm wondering if you could kind of expand on that, and in the context of our New Legal Frontiers theme. Where is this going? Is there going to be more free speech type cases in schools, or are we going to see an expansion of the application of Mahmoud to those types of contexts? Does anyone want to speak to that?
Well, they're having a debate about it next, so.
All right, maybe we should.
Yeah, I mean, there are a pair of cases at the cert petition stage at SCOTUS right now that are challenges to public school social transitioning of students without the consent or knowledge of the parents. And the parents' objections there are not rooted at all in religious concerns, but rather moral and scientific concerns. I think the court's supposed to conference on the first of them on November 21st. So it could be the case that later on this term at the Supreme Court, we could have a case that raises these issues, but in a non-religious context. And it would be interesting to see what the court does in that situation. I'm not aware of other than those two cases, I'm not aware of any other kind of.
Well, they're the medical care cases that, I mean, the challenges that I think led to Scrimeti, those cases have been filed, parents saying, my parental rights include the right for me to help my child medically transition. And I think those cases are out there. Those are not religious cases, so far as I know. And back in the olden days when I was at IJ, there were cases that were challenging like mandatory service requirement. There have been parental rights challenges. that were not religious. One of my favorite that I love to teach in education law is a case called Brown versus Hot, Sexy, and Safer. LaDawn remembers. It was a really bad sort of sex ed, I don't know, assembly, let's say. And they
Of
didn't
which
tell
the
the
less
parents.
said, the better.
It was terrible. Like the woman, like how told the kids to put like a condom on a banana, and it's really, it's actually worth reading because it's so bad. But the First Circuit's like, yeah, and you don't have parental right to be told before your kids get taught how to put condoms on bananas in public high school. So there are these cases that are out there.
Nicole, I have a question for you. So you said, we need to be weary of kind of invigorating Meyer and Pierce because they can just be as easily put to kind of, more left-leaning causes. Why is that a problem, and would not that just be, determining the applicability of Pierce and Meyer to these various situations, whether it's the social transitioning cases or the right to, provide, medical treatments to your child? It would just shake out in this kind of level of scrutiny, right? The application of whatever level of scrutiny. We have no clue what level of scrutiny applies. These rights are fundamental, supposedly, yet the court has never applied strict scrutiny to them. You have some lower courts applying rational basis. I mean, this is something that the court is going to have to straighten out. But would not the application of Pierce and Meyer to these various situations, kind of left-leaning or right-leaning, just shake out in courts?
Yeah, I want to clarify. I said we should be wary of overclaiming what Pierce and Meyer mean, because it could backfire. Because I think the court is going to be worried in the non-religious context about putting more into Pierce and Meyer. My other point was just it was not really about reason to be wary. It was just an observation that these cases go both ways. So, and as for the tiers of scrutiny, I mean, I don't even know how long the court's going to be doing that anymore. So, we're moving towards something that is not tiers of scrutiny in a lot of the rights cases. So I think we might just get like a list of what things Pierce or Meyer or what parental rights are protected all at Bruin, and we might not like it. For those of us who care deeply about parents, it might not be as broad as the parental rights activists want on the left and the right. But for me, I guess I just want to know what the right answer is. So I was making two separate points.
So if I could just make a couple of comments. So one, I mean, as I mentioned previously, on the gender transition cases in particular, these raise the issue, as do some other kinds of cases, about parental exclusion, like cutting the parents out of the process. And I think that is a way to kind of simplify some of the substantive due process inquiry. I mean, even Justice Thomas, who's no fan of substantive due process and really doesn't like where the court has gone on at least the student free speech component of rights in public schools, cites Pierce in his Mahanoy separate opinion for the idea that, well, when you cut the parents out of the process, there's probably a claim. So I think that's one way to think about those cases, but that doesn't really address the broader question of this kind of the authority of public schools, which is kind of rooted in democratic authorization and also kind of rooted in parental delegation, and we're not really sure how that all works together, and it's historically very complicated. That doesn't really get into that. On the point about Brown, of which I'm going to encourage you, for the sake of your souls, to not read and just take our word for it that it's terrible. This actually points to where courts are already trying to chip away at Mahmoud. Courts are already trying to turn Mahmoud into just about books that are being read in a classroom, and they're not about, as was the case in Brown, a school assembly or field trips or things that happen even like, and you could look at the gender transition cases as another instance. This is a school policy that's not really curricular. To me, this is amusing because after Yoder was decided, the argument was in the lower courts, well, one, if you're as socially isolated as the Amish, maybe you have a parental religious claim in public schools. And two, the other thing is, the closer you get to curriculum when you're challenging what's going on in public schools, the less likely you are to have a claim against what the schools are doing. Now it seems with Mahmoud, it's the inverse, actually. The further you are from curriculum, the harder it's going to be as a parent to bring a claim, which is really remarkable because if we're thinking about this issue of delegation to the public schools in the background, They certainly were given some authority to come up with curriculum. It's not really clear they were given the authority to say, help a child transition on gender, for example.
So one context for parental rights outside the school area is in abortion. The Supreme Court recently denied cert in Montana versus Planned Parenthood, and the QP there was whether parents' fundamental right to direct care and custody of children includes a right to know and participate in decisions concerning a minor's medical care, including the decision to seek an abortion. The case was denied for vehicle issues, but Justices Thomas and Alito issued a statement noting that it was not a rejection of the question itself, and typically that is read as an indication that they would like to see the question come back to the court. So, does the panel have any thoughts on that context?
I wasn't aware of that particular petition and denial, but I mean, does the right encompass parents' right to be involved in medical decisions? Yes, I think that's undeniable. Now, I'm not sure what the particular law at issue in Montana was and how that would have shaken out on the merits, but I don't think it's unreasonable. I think it's just true that the right recognized in Pierce and Meyer isn't limited to decisions about education, but rather to medical decisions concerning your children as well.
Yeah, I don't know about that case. I do think if to the extent there are parental rights, it has to be that you have the right to some degree of power over your children's medical care. I mean, although there are I don't think that is limitless. I don't think it violates Pierce to say we're not going to do gender transitions until the kid's 18. I mean, I think that's just about the scope of the right. I mean, the other thing I think, where Pierce's shadow is the largest, and well, this is to your point. I mean, maybe this is signaling that they have more appetite for expanding it than I think they do. But the biggest thing is obviously Pierce's shadow is the biggest in the family courts, and in the family courts, the questions about taking your kid away. I mean, my brother just adopted his stepchildren, twins, and the biological father fought it. He didn't have any religious reason to fight it, but I would think, obviously, that we want parents to have rights in family courts, and not just religious rights. So I think that there is some universe of parental rights that we all think exist. And that if we just sort of, like the government started willy-nilly taking kids out of their parents' houses and putting them in other houses, we would think the parents had rights even if they weren't religious claims. So that's another context.
So I want to make sure that this has not happened, so I'm just going to make a clarification. My point about the relationship between parents and public schools and why it's right to think of Pierce and Meyer as religious exercise cases is not to say that there aren't parental rights outside of the education context that are non-religious. The Supreme Court has already made that very clear in cases like Parnham, for example, which is probably maybe more on point to the idea of medical kind of treatment issues related to children and parents. So there's what I'm pointing to rather is this more unique question about how do you think about the scope of authority of parents over the education of their children when public schools also make a claim to that authority as well.
To throw something totally different into the mix here about the scope of Pierce and Meyer, I think it's also important to remember that yes, those are parental liberty cases, but the cases were brought by education providers, right? Robert Meyer was a teacher, he might have been a parent, but he was bringing the case in his capacity as a teacher. The Society of the Sisters of the Holy Names of Jesus and Mary and Hill Military Academy were schools. They brought the challenge in Pierce. And yes, the court recognized the rights of parents using their schools, but the court just as much recognized and just as much relied as a basis for its decision on their economic rights to provide services to parents who wanted them. So I think that that's a topic for another discussion here, but I think that gets back to this idea that Pierce and Meyer are not at root really free exercise cases. They're much more than that. They take a much more comprehensive view of liberty, and I think we often forget the fact that they were not brought by parents.
With that, why don't we open the floor to questions from the audience? If folks can find their way to one of the microphones to ask your questions. Yeah.
Hi, my name is Jake Minus. I'm affiliated with both with Atheists for Liberty and as well the J. Reuben Clark Law Society of Brigham Young University. My questions are primarily directed to Professor Garnett and others about non-religious parental rights issues. The Sixth Circuit, I'm not sure I'm pronouncing it right, Olakanzi case included, the plaintiff group included what they would call people with scientific and philosophical objections to pronoun usage. Now, I've been listening to this conversation about, there's not a big appetite for going back to substantive due process and parental rights. But here's my question, is can these kinds of objections be fit in terms of religious liberty for non-religious people, such as, the First Amendment guarantees my religious freedom as a non-believer. So let me put it this way, Professor, you may not want to say that trans women are women because it offends the teaching of your one true church. I don't want to have to say it either because it offends scientific reality, which is my one true church.
I might let the religious liberty litigator define what religion is. Obviously, that's a vexing question for all courts to figure out what religion is. I do think you could get to a point where you define it when religion is everything, and then that might be problematic. So I think these are just, that's a problem. Now, what you seem to just say, I would think Philip Hamburger would say these are free speech claims or something. And he has made those arguments. Do you want to define religion?
I approach the role with humility and modesty.
Hi there, Will Trackman from Mountain States Legal Foundation. What are a parent's rights to opt their kids out of DEI curriculum and events at public schools? There's definitely DEI assemblies and signs that say we're all committed to equity here. And if I have to opt my kid out all year, is there a voucher that comes along with that?
Well, I think this is going to play out in the courts, and that I assume your parents don't have religious objections to DEI. They just don't want them exposed.
I'm sure I could find a passage in the Bible to support me, right?
Yeah, one should probably avoid overclaiming, but we don't know what's going to be, what kinds of things get opted out. I actually do not, and right after Mahmoud, I started getting phone calls and people saying, can't we use this to get a voucher? And I actually don't think that's a good strategy. I don't think the court's going to go there, and I don't think that judicially administered voucher, I think you seem like a great guy, but I'm not sure I want you running a voucher program in New York. And so I think that's unlikely that remedy. I think there will be lawsuits filed about it. I don't think that can be stretched that far.
And I would not advocate bringing lawsuits for an affirmative voucher remedy from the court. But where a legislature, in its discretion, has provided such a program, and then a court invalidates it simply because parents are using it to exercise a fundamental right, I do think that's a problem. But I would not advocate going to court with Mahmoud or any of these other precedents and saying, court, you must give my kid a voucher.
Thank you.
Hadley Arcus, James Wilson Institute. I'll take a version of the first question from another angle. Education almost has to be moral education. Public education must have a component of moral education. McReynolds said in Myers that at least you're going to have to be instructing people in the principles of the civic order. The people in Maryland thought they were offering moral instruction, not religious instruction. But the moral instruction was based predicated on a falsehood. You cannot simply deny the inescapable objective differences between males and females. That is the way we must be constituted. So the question I raised for Will, you don't need to be religious to counter that moral argument. I assume that the right you are vindicating in this case was accessible even to people who are not religious.
So the claim that our clients had was that their religious authority as parents to direct their children's religious upbringing was being burdened by not knowing that this instruction was happening and having the opportunity to opt them out of that instruction. That's somewhat different than saying that the instruction itself was completely objected to on religious grounds. They had religious objections to the instruction, but there were also parents who didn't agree as a matter of, well, to just use the words of the Montgomery County Public School teachers, you're asking us to say things to kids that are facts that some of us don't think are facts. So that is present. What the right that was being asserted, though, is their religious authority as parents to shape them in a way of life that understands, in this case, man and woman as organized in a particular way for the ends of their bodies. But the parental right is kind of separate somewhat from the objection itself. The parental right is a right to direct the children's religious upbringing.
Okay, forgive me, Rich, I'm sorry for the foul, but you did not choose to contest the argument by challenging the substantive moral ground of that legislation. No, it's quite typical that when we think we cannot challenge the right to abortion or same-sex marriage, we flip over into the religious claim to be exempted on the basis of beliefs. In that case, we run back into Walter Burns' objection to Yoder. He said, well, we thought for years we'd established a constitutional right to and racial integration, but now somebody could come along with, as Nicole says, somebody professing to have a religious objection to it. So it's, again, what we encounter when we're reluctant to challenge the substantive moral ground of what we're dealing with.
That's why but Hadley, that's why we need parental choice. I mean, there's no such thing as a values-neutral education. It is, everything at every school is inculcating some values.
Right.
And I mean, there's not really a legal argument that you can say, like, that's just wrong, so you can't teach it. That's not really it's not going to be a winning legal argument, but giving parents the option of leaving and finding the education that aligns with their values, even values that I might object to. I understand in Florida there are DEI learning pods and LGBT micro schools. I think that's the answer.
I'm with you on the policy argument, but that still evades the question that's arises as a constitutional question. But I'm with you on that. Thanks.
Next question.
Hi, Richard Samp from Arlington, Virginia. Mr. Bindas, as I understand what you're saying, if the state constitution prohibits funding of private schools, that would violate the federal constitution. After Roe v. Wade said there was a constitutional right to abortion, Congress passed Hyde amendments that prohibited funding of abortion. The Hyde amendments were upheld by the courts as constitutional. How would you distinguish your argument from those decisions upholding the Hyde amendment, assuming you think they were correctly decided?
I do think they're distinguishable. So obviously there's no longer a fundamental right to abortion, right? So that's one difference, but that was not true when Harris and Marr, the two cases you're referencing, were decided. But in those cases, there was not a state constitutional bar on the legislature's ability to fund abortion. They involved a legislative policy choice not to fund, right? Here, the legislature has made a legislative policy choice to fund, and yet the legislature's policy decision is being overridden by a court pursuant to a state constitutional provision that explicitly discriminates against parents who exercise their peers' rights. So I think the lack of a constitutional bar, that it was merely a legislative policy choice in the Hyde Amendment cases, is significant. And in fact, the court noted in Marr versus Roe, which was not the Hyde Amendment case, but a Connecticut case under, concerning state Medicaid policies. The court said Connecticut is free through the normal democratic process to decide that abortion benefits should be provided. And in Harris, the Hyde Amendment case, the court said whether freedom of choice that is constitutionally protected warrants federal subsidization is a question for Congress to answer. Here, the legislatures have made the policy decision to fund the thing, and yet the court now, through a state constitutional provision that discriminates against one group of citizens, is saying, no, you can't make that policy
But Michael,
choice.
what if, when Roe was the law, Indiana had amended its constitution and said, in Indiana, we won't, no funding for abortion ever? That would be unconstitutional?
If I think that would be a close question. But I do think there's there's a significant difference between abortion and education that perhaps would kind of make the analysis different. In the abortion context, a decision not to fund the thing is not a penalty or a coercion, right? It's a policy choice not to fund the thing. Education is very different, right? Again, I think the appropriate abortion analogy, it would have to be something like this, right? Number one, Supreme Court recognizes a fundamental right to obtain an abortion, including at a private hospital. Number two, the state passes a law compelling you to get abortions, right? That's the compulsion angle that's different in education, I think. Then the state gives you a positive state constitutional right to a free state-provided abortion at a state hospital. Then the state taxes you to pay for that state-provided abortion, and then the state amends, as you said, the state constitution, and says, under no situation will we fund an abortion procured at a private hospital. That would be the abortion analogy. I think it's just completely different. A decision not to fund abortion is not an attempt to make an end run around Roe. It's just a decision not to fund abortion. Here, I don't think there's any question that these lawsuits are an attempt to evade the court's decision in Pierce and Meyer.
We have time for one final question.
I'm Mike Ferris. I'm the founder of the Homeschool Legal Defense Association and past president of Alliance Defending Freedom. I wanted to get your reaction to a law review article that I published on an alternative to substantive due process for parental rights, and that is arguing that it should be decided always under procedural due process. There's 13 Supreme Court decisions ever where parental rights were the or a major component of the decision. In roughly half of those cases, the Supreme Court has used procedural due process, and on the other half, they've used substantive due process without ever explaining why they choose one and the other. But the line of demarcation that becomes discernible is if you're taking away all of parents' decision-making, that is denying custody, they use procedural due process. But if you take away one element of parent decision-making, they use substantive due process. When they describe the existence of the liberty interest, they use those two lines of cases interchangeably. There's no rhyme or reason to them. And 100% of the justices that have ever written in this or voted in these 13 cases have said parents' rights exist as a definable legal interest. My contention is it should always be procedural due process. If you're taking away one decision-making area or all decision-making areas. And the process is you have to prove that parents are abusing, neglecting, or abandoning their children before you can interfere with parental rights. You have to prove that with clear and convincing evidence. So I think that that's a non-substantive due process basis that's effectively been embraced by every Supreme Court justice that's ever looked at the question. I'd like your reaction to those theories.
Well, if you're saying I'm going to prosecute you for homeschooling your kid, then, and obviously, or you're getting some kind of penalty, then that is process. I think the problem, is that in the context of, say, the public school, I think the court would say the process that you get is the legislative process that there's lots of cases on that. So, like, procedural due process in the political context is typically satisfied by the legislative process, the political process.
Well,
there's that bifurcation.
Except for in the Supreme Court cases where they've just used procedural due process, there's a specific showing that has to be made that the parent has abused, abandoned, or neglected the child. It's not just that there was a legislative process or you get a trial for homeschooling. They have to prove, as in Yoder, the harm to the child was that if the child was functionally illiterate, and the literacy and self-sufficiency were the two governmental interests. And so they have to prove, I believe, that. And so I just commend you. Take a look at the article. It's not time to debate it out fully, but and if any of you think it has legs, I'd love to see reactions to it.
Thank you. We'll do that. Please join me in thanking our panel for an excellent conversation.